Hi, my name is Chris Addig with the Veterans Law Blog. Today I want to talk to my fellow veterans that have a PTSD claim or appeal that's based on a non-combat related stressor event. Have you ever tried to convince the VA that that stressor event occurred outside of combat? It's a lot harder for those of us that were not combat veterans. If you didn't serve in combat, you have to corroborate your stressor event. You have to prove to the VA that that event occurred. It's really hard, isn't it? Today I want to talk to you about a new case out of the Court of Appeals for Veterans Claims that requires the VA to go even further in its duty to assist the veteran. Now, this video isn't legal advice. It's meant to be an educational tool to help you better understand the law of VA claims so that you can do it yourself or you can keep a better eye on the attorney or VSO that's handling your VA claim or appeal. Today I want to talk to you about the Gagne case. If you get on the Court of Appeals docket, and I'm going to pop that link up here on the bottom, look for case number 14-0334. It was decided October 19th, 2015. I'm going to give you the full site in the Vet app Court Reporter here in a moment, but I want to talk to you about the case. So any of you that have tried to service connect a post-traumatic stress disorder claim for a non-combat related event know that it is extremely difficult to corroborate that your stressor event occurred. And when I say corroborate, I mean prove to the VA that that event actually occurred. So maybe in peacetime you witnessed a soldier who was cut in half when pinched between two tanks in a training drill. Or maybe you saw your battle buddy plummet from the top of a rappel tower on an obstacle course, crushing his skull. Or maybe you watched a little kid get rolled over by a tank on a training exercise in Korea. These are all non-combat events. These are all real events that I have seen in real veterans' claims. They are not made up stories. But under the current law of PTSD claims and appeals, your word that something happened is simply not good enough for the VA to believe you. So veterans with non-combat stressor events have to go an extra little bit of distance to corroborate the stressor, to prove that stressor event occurred using quote-unquote credible evidence. Now, credibility is one of those $100 lawyer words, and there's other posts on the Veterans Law Blog that talk about credibility in a VA claim or appeal. I want to talk to you about the corroboration of the stressor event. You can use things like buddy statements or newspaper articles or medical treatment records. That's not what all this post is about. This video post is about the JSRRC, the place that stores a ton of never before seen or never before identified information about incidents that occurred in the military. The JSRRC is the Joint Services Record Research Center mission. That's a mouthful, isn't it? At that facility, it's a Department of Defense facility, not a VA facility. They have access to information from tens of thousands of military units over several decades. The problem is you, the individual veteran, can't get access to it. Only the VA can. At least that's what the JSRRC says. They say when the regional office determines that information from military unit records is necessary to process a VA claim, the regional office will request this assistance from the JSRRC. So think of the JSRRC as a secret book that only the JSRRC can look at, that only the JSRRC knows what's in it, and only the VA can ask the JSRRC to search the secret book for secret evidence that your non-combat stressor event occurred. Okay? The VA has long used this power as a way to deny veterans claims or appeals for PTSD in non-combat scenarios. Here's how the game is played. It's played the same way in almost every single case. First, the veteran gives details of an event that occurred outside of combat. A common scenario is witnessing a training death, military sexual traumas, or other events of that nature that occur outside of the combat context. The veteran, due to the passage of time, the symptomatology of their PTSD, or basic human brain power, forget the precise date that the event occurred. So the VA starts barking and hollering in its duty to assist letters that it needs the veteran to define a 60-day window in which the event occurred, or they won't ask the JSRRC to corroborate the stressor. Again, that's a made-up excuse, as I'm going to explain in a little bit. So when the veteran can't provide that exact 60-day window, the VA denies the claim or the appeal for a failure to cooperate, or on the grounds that it can't fulfill the duty to assist without more information, or on the grounds that it can't corroborate the alleged stressor event. This is all absurd, by the way. To require a veteran to remember the specific date of an event or pinpoint a 60-day window when something happened is absurd. Listen, the year before President Obama was inaugurated, I witnessed a drunk driver strike and kill the driver of a car that was stopped right in front of me. Every detail of that incident replays in my mind like a movie scene that I can't forget. But you could offer me $1 million to tell you what month it happened, And all I can tell you without doing a lot of digging and a lot of research is that it was sometime in 2008. The only reason I can remember that is that I was interviewed by the prosecuting attorney who was trying to put the drunk driver in jail. That interview occurred on the day of Obama's inauguration. I couldn't tell you the exact date or even the month. All I remember is that it was sometime in 2008. That's human memory, folks. Most of us don't remember exact dates of even memorable incidents. I'm forgetting my anniversary all the time. But back to our scenario. When the VA plays its JSRRC 60-day window game with one veteran, he'd had enough. He went ahead and appealed to the Court of Appeals for Veterans Claims, and as a result, we have a new rule of law which says exactly what the VA has to do to fulfill the duty to assist when it comes to seeking records from the JSRRC. Here's how that case played out. The veteran was stationed in Thailand during the Vietnam War. First of all, anybody that says that isn't combat doesn't know what happened in Thailand during the Vietnam War. That aside, this veteran was building a road between two of the bases that were in Thailand. One day, he watched a truck backed into and killed an NCO that was on the site. Some other things happened. It was a little bit more complex than that incident. I won't dive into it in too great of a detail, but the veteran filed a claim for PTSD some years later. It took him realizing that this incident was why he was having suicidal ideation and other symptoms of PTSD. In his case, the VA said this is a non-combat stressor because you were in Thailand during the Vietnam War. Apparently there was no conflict, right? No combat, right? Those of you that served in Thailand during the Vietnam War know that that's a big pile of, well, I won't say what it is on video. But anyway, the VA refused to ask the JSRRC to verify this veteran's non-combat related stressor because the veteran couldn't remember the 60-day window in which the event occurred. Instead, the VA denied the claim for a failure to locate credible evidence of the stressor event. The veteran called bullshit and went ahead and appealed. He got all the way up to the Court of Appeals for Veterans Claims, and where he argued that the VA's duty to assist couldn't be limited to 60-day windows. By the way, he had an outstanding advocate named Amy Odom who works over at the National Veterans Legal Services Project, or NVLSP. Check him out. Amy's an awesome attorney, did a fantastic job on this case. The veteran in that case pointed out that the VA's duty to assist is fulfilled only when future efforts to obtain records would be futile, or it's established to a reasonable degree of certainty that the records don't exist. The VA, on the other hand, argued it was futile to ask the JSRRC to search through a year's worth of records for a particular incident, when the JSRRC and the VA had previously decided it was the most efficient and the easiest way for them to search was in 60-day windows. So, in come the VA attorneys, the Office of General Counsel. They made the veteran's attorney brief the case, go all the way through to oral arguments, and only after oral arguments did the VA realize how bad its arguments were. And shortly after the oral arguments, the VA went ahead and changed its position, expressly conceding that it had failed to fulfill the duty to assist by not searching through the records as requested by the veteran. As an aside, this case was at the court for 20 months. The appeal was filed in February of 2014. The VA Office of General Counsel's willingness to back down so easily after oral arguments, after making the veteran fight for almost 20 months at the court, makes me wonder if this is just another example of the Office of General Counsel wasting everybody's time with arguments that it knows it cannot win. The Veterans Law Blog has reported on several cases about this very scenario this year, including our assessment of how the VA's Office of General Counsel is wasting millions and millions and millions of taxpayer dollars each year on frivolous arguments on appeal. But in any event, the court in this case ultimately made it clear that the VA's duty to assist in asking the JSRRC for evidence corroborating a stressor was not limited to 60-day increments. The VA fulfilled its duty to assist only when one of two scenarios occurred. First, it has to be reasonably certain that the records sought do not exist. That means they can't be in existence, and it has to be reasonably certain that nobody's ever going to find them. That's one scenario. The second scenario is that future efforts to find the records would be futile. And the court actually defined the word futile as, quote, serving no useful purpose, completely ineffective. So, what does that mean? How do you use this decision in your case? Because that's a lot of information that I just threw at you in a very short 5 or 6 minute video. I want you to ask yourself the following questions and then follow this logic and this workflow if you have a non-combat PTSD claim or appeal and you're having difficulty getting the VA to use the JSRRC to research your stressor event. First, ask yourself, Do you have a non-combat PTSD stressor event? If yes, send the VA a sworn declaration. No, don't use that 214138. I tell you why on the blog elsewhere, but use a sworn declaration laying out the date ranges that you think the event might have happened. I recommend always going with a broader range than you think, just because with the passage of time, our memories fail. It's natural human brain power behavior. If you think something happened in the summer of '68, I want you to broaden that range in your statement to say sometime in the year 1968. Okay? If you're pretty sure that an event happened in 1979, don't trust your memory. Our memories play tricks on us, right? So add a year to each side to be sure and say, I think the event occurred somewhere between 1978 to 1980. Obviously, the further back in time that the event occurred, the broader the window that you want to provide. So if something happened last year, you don't want to say, I think it happened in 2014. That's going to be a little bit tougher to convince the VA to look at that broad of a window. But most of the time when we're using the JSRRC, we're looking at events that occurred sometimes 20, 25, 30 years ago, typically, most commonly, Vietnam-era veterans. But once you've added those facts into your declaration, I want you to add this statement right before you sign it. I want you to say, I cannot narrow the time frame of this reported stressor to a 2-month period. End of sentence. Just say that sentence right in there. Then cite to the Gagne case for the position that the VA only fulfills the duty to assist if it submits multiple JSRRC requests for each 60-day period in your search range. Okay? It's as simple as that. Lay that out there. Hopefully that will help the VA to search the JSRRC. Again, it's a big secret book that only the JSRRC has access to, so even if your stressor event is in that book and they lie and say it's not, you probably don't have any recourse, at least not enough that I can talk to you about in this video. We'll deal with that in a separate post, a separate video post or a written post someday on the blog. In case you need that cite to the Gagne case, the actual legal site in the Vet App Reporter is 2015 U.S. App Vet Claims Lexus 1404, October 19th, 2015. I'm popping it up on the screen for you right now. Probably within a month or so, it'll actually show up in the actual reporter and there'll be an actual Vet App site. So, any questions, feel free to send me an email at support@veteranslawblog.org or pop on over to the Veterans Law blog and submit a request for information using the links that are on that site. Thanks for taking the time to watch this video. Let me know if there are any topics that I can cover in a future video blog that would help make it easier for you to prove and win your VA claim or appeal. Take care and good luck.